Hello everyone, today I'm going to be talking about what is quite possibly one of the most insane stories and lawsuits to ever come out of the state of California when it comes to gun rights. Now, even though this might be the most insane story I've ever heard when it comes to red flag laws in this state, it's kind of one of those things that is exactly what every single gun owner said would happen. It's going to be a wild ride. We're going to be talking about it. I'm also going to give the shout out to the two organizations and the legal team that is representing this case. But before we do, I do want to say thank you to the sponsor of today's video. Today's sponsor is Zydex. Now, if you're a gamer like myself, you might be interested in getting a new PC. The problem is, right now, graphics cards are almost impossible to find, and what I've been recommending most of my friends do is find a reputable manufacturer who makes pre-builts, and that's where Zydex comes in. Zydex makes laptops, PCs, and all sorts of other custom gaming gear when it comes to what it is that you're looking for. High power, high efficiency. Zydex is an awesome company to deal with. I've heard nothing but good things on the internet, and I am happy to have their support. If you're not looking to build it yourself, having the comfort of a professional company do it for you is definitely something a lot of people would be interested in. This comes from the Second Amendment Law Center in conjunction with the CRPA. 2ALC and the CRPA, along with Michelle and Associates, one of the biggest law firms when it comes to Second Amendment rights in the state of California, but also big cases nationwide as well. They are the ones that are running this. Now, here's the story. Now, this is going to be quite a wild ride, so I'm going to ask you to just kind of stick with me as I basically read the entirety of this article. I'm not sure how this slid under the radar so long. I feel like I would have found out about this sooner. Maybe some of you have, but if you haven't, here we go. Second Amendment Law Center, California Rifle and Pistol Association announced support of lawsuit challenging restraining order firearm prohibition. Here's the story. Imagine living in the same house with your spouse for over 50 years. Your front lawn has a sapling that, over the course of time, has grown into a beautifully tall tree. But the neighbor next door who moved in just a few years ago doesn't like the tree. So she conspires to falsely accuse you of assault and battery after you refuse to remove it. You get arrested as a result. She then seeks a restraining order against you based on her false allegations, files both a civil case and a small claims case against you, and to top it all off, California law takes away your right to own or possess firearms in connection with the restraining order, before you even have a chance to respond. Think it can't happen? Well, that is exactly what happened to Richard and Miranda Wallingford, only their story gets worse. Much, much worse. This is the exact kind of things that we talk about when it comes to red flag laws nationwide. Anytime these sorts of things are introduced, people always say these are going to get abused, and everyone that is for red flag laws says, oh, they never get abused. It's never going to happen. You're just being a conspiracy theorist. You're just being paranoid. Exhibit A. As a result of their new neighbor's false allegations, the Wallingfords hired a home security company to install cameras on their property. The purpose was to prevent the neighbor from making additional false allegations in the future. Immediately after the installation, but before a hearing on the restraining order petition was held, the cameras captured the neighbor making threatening gestures and attempting to damage the Wallingfords' trees. These images were shown to the court at the restraining order hearing, which ultimately concluded that the Wallingfords did nothing wrong and dismissed the petition against them. Their criminal assault and battery investigation was dropped by the police, both the small claims and civil cases were dismissed, and the Wallingfords' firearms rights were also reinstated. Keep in mind, without ever having been proven to committed any crime, they had their rights stripped away from them. Take the guns first, due process second. Tell me who said that. This is where the Wallingfords' horror story should have ended. At the restraining order hearing, the Wallingfords went on record to state that they simply wanted to put the matter behind them and asked the neighbor to cease and desist her hostile behavior. That, of course, did not happen. Late in the evening, on the same day the neighbor's civil case was dismissed, the security cameras captured the neighbor coming out onto the Wallingfords' property and pouring bleach on the tree. The Wallingfords called the police, but the police took no action. The neighbor's behavior continued to escalate. She was recorded yelling verbal threats of violence from her front yard and making several throat-slitting gestures directed at the Wallingfords' cameras, at least one of which involved the use of a knife or similar cutting instrument. Now, in fear for their personal safety and seeing no other option at this point, the Wallingfords filed a petition seeking restraining order against the neighbor. This is absolute Giga Chad, Giga Karen moments, but it does get crazier and it does get worse, but it sets the stage for what is quite possibly an excellent case to be heard that could overthrow the red flag laws in the state of California and potentially nationwide. But before a hearing on the Wallingfords' petition is held, the neighbor again files a petition seeking a restraining order against the Wallingfords. This time, the neighbor claimed the Wallingford security cameras constituted harassment while also raising the same allegations of assault that were previously ruled on and dismissed. Astoundingly, the court did something wrong here. I know that's going to be a surprise to some of you. The court granted the neighbor a temporary restraining order, resulting in the Wallingfords once again losing their Second Amendment rights until a formal hearing could be held. Again, lose your rights before you actually have your day in court. Worse still, the court later recognized that it mistakenly read the neighbor's petition to include new allegations of assault, not the same allegations raised previously. Had it not made this mistake, it would not have issued a temporary restraining order. Nevertheless, the court refused to dissolve the temporary restraining order until a formal hearing could be held 60 days later. So the court's messed up, acknowledge that they mess up, and then they say, yeah, we're going to keep to that mess up. That seems right? Upon first learning of their neighbor's complaint about the security cameras, the Wallingfords immediately repositioned the cameras to ensure only their property was in the camera's field of view. They did so despite the areas of the neighbor's property also being captured were publicly visible from the street. Although the court immediately granted the Wallingfords' petition for a restraining order against the neighbor because it found no legitimate purpose to make a throat-slashing gesture towards the security cameras or mooning the cameras, spraying the cameras with water, or other similar conduct, the court also found that the Wallingford security cameras constituted harassment. So even though they say that the restraining order has merit, they're still saying that having security cameras facing a publicly viewable section of your property is harassment. But the courts also expressly noted the cameras have since been repositioned such that they point only at areas of the neighbor's residence in public view, which the court finds acceptable. Nevertheless, the court issued a 3-year restraining order against them despite no other findings of harassing behavior or that the Wallingfords are in a danger to the public or to themselves. What's more, there was no evidence that the Wallingfords were directly involved in the installation of the cameras to begin with. The courts gave the restraining order to the Wallingfords against their crazy Karen neighbor, and then the courts also file a 3-year restraining order against the Wallingfords for placing the cameras there. As a result of the restraining order issued against them, California law prohibits the Wallingfords from owning or possessing firearms for its entire duration, all because the Wallingfords took steps any reasonable person would likely have taken to protect themselves after being falsely accused and harassed by a vile and hostile neighbor. And to this day, the Wallingfords' neighbor continues to harass and intimidate them with no action being taken by law enforcement against her despite multiple 911 calls and the existence of a restraining order against the neighbor. The Second Amendment Law Center and the California Rifle and Pistol Association are proud to support the Wallingfords in a new lawsuit challenging California's laws prohibiting them from owning or possessing firearms due to the restraining order issued against them. The Wallingfords, through their legal counsel, are seeking an injunction against the prohibition while the lawsuit is litigated. A hearing on the Wallingfords' request for an injunction is currently scheduled for November 1st of 2021, so that's just a few weeks away. It is absolutely insane. We've talked about things like this before about it only takes one crazy person to abuse the system as it currently stands to completely disarm you of your right to keep and bear arms and protect yourselves without any real proof. And this is a perfect example of it. This is an example of where the courts failed, the courts acknowledge their failure, the courts still give a restraining order, and the courts then are putting them in a situation where I would argue that the Wallingfords are probably one of the people in the state of California that could most likely or most easily argue their right to get a CCW in states like or in counties like Santa Clara, where you basically have to bribe the sheriff. Now, everybody has the right to keep and bear arms. No free man shall be debarred the use of arms. This is just one of those examples of where you could very clearly show a direct and needed reason to own guns. I would say that the likelihood of me ever needing to use a firearm to defend myself is very low. But it's still my right to be able to have the tools to protect myself from other persons, the government, whatever it is. Alien invasion, zombies, I don't know. It's October, it's spooky season. The ghouls and gals, they're coming out, right? But this is a situation where someone could argue they have the very much urgent need to have the means to protect themselves, but the courts have stripped their rights to protect themselves for up to 3 years. And it's their responsibility to now fight it in court. Absolutely insane. I'd love to hear what you think down below. Have you ever experienced a situation like this? I'm going to be leaving links to the lawsuit itself from the CRPA and from the Michelle and Associates, their website. You can take a read at that down below. This is a very interesting case. I'm very curious to see how this will turn out. I'm hopeful that this is going to end up being a positive way to stop red flag laws, because it is truly the perfect type of defendant, in my opinion, for this kind of thing, because these people did nothing wrong and their rights are being stripped and taken away from them. This isn't someone where they were potentially a wife beater or potentially whatever, regardless of whether or not they were proven to do it or not. This is a very clean case to be the representative case for this kind of thing. So I'm very curious to see how it goes. I'm wondering what you think down below. Let me know what you think. You guys know the drill. Have fun, be safe, stay dangerous. Peace. Also, I want to say thank you to Johnny B and Emily over at shallnotcomply.com for getting our new merch out. This is the Don't Google the Yankee Boogle shirt. I'm very happy with how these turned out. I had this idea for a long time. We finally got it up and running and printing, so there is a merch link down in the description below. Anything you buy from that website, if you use my link, will support me. Thank you.